Our next ethical theory is virtue ethics. Virtue ethics focuses on integrity. The virtue ethics approach focuses more on the integrity of the moral actor, the person, rather than the moral act itself, the decision or the behavior. The goal here is to be a good person because you want to be a good person. Although virtue ethics is a philosophical tradition, began with Aristotle, a number of contemporary ethicists, including business ethicists, have returned it to the forefront of ethical thinking. A virtue ethics perspective considers the actor's character, motivations, and intentions. According to virtue ethics, it's important that the individual intends to be good and exerts effort to develop himself as a moral agent, to associate with others who do the same, and to contribute to creating an organizational context that supports ethical behavior. This does not mean that principles, rules, or consequences are not considered. Just they're considered in the context of assessing the actor's character and integrity. One's character may be assessed in terms of principles such as honesty, in terms of rule following, did the actor follow his professional code of ethics, or in terms of consequences, as in the physician's agreement to above all do no harm. Motivations and intentions are important to ethical decision-making, as the law acknowledges. Society judges a person less harshly if he or she did not intend to commit the crime. That is, it was an accident. In virtue ethics, a relevant moral community that holds you to the highest ethical standards may define one's character. Therefore, it's important to think about the community or communities in which the decision maker operates. Think about yourself. What community or communities do you look to for guidance in deciding whether you have acted as a person of integrity? Are you guided by the standards of your professional association, the regulatory community, your religious community, your family, your company's ethics office, or the broader public? Know that unless you work in a highly ethical organization, the context, the relevant moral community is not your own work group or your organization. Let me say that again. Know that unless you work in a highly ethical organizational context, the relevant moral community is not your own work group or your organization. A virtue ethics perspective requires that you look to the community that will hold you to the highest ethical standards and support your intentions to be a virtuous person. A virtue ethics approach is particularly useful for individuals who work within a professional community that has developed high standards of ethical conduct. For example, the accounting profession has developed a code of conduct for professional accountants. Being a virtuous accountant will mean abiding by that code of professional responsibility. The same goes for certified financial consultants, engineers, lawyers, physicians, and psychologists, who all agree to abide by the profession's rules and standards. Such professional codes are generally living documents that evolve with changing times. For example, building on 20 years of thinking about ethics and torture, a committee of the American Psychological Association developed new standards in 2009 consistent with its do no harm principle. Without exception, the new APA standards prohibit professional psychologists from participating in torture. Psychologists are required to disobey orders to torture, intervene to stop torture, and report torture if they become aware of it. A decision maker can often rely on such relevant community standards to guide decisions and actions. The assumption is that the professional community has already done this type of thinking and done it carefully. Consider, for example, the U.S. legal profession. The rule of attorney-client privilege requires criminal defense lawyers to keep information shared by their clients completely confidential. This rule is based on the idea that in order for defendants to get the best possible defense, they must feel free to be completely truthful with their lawyers. The underlying principle of the U.S. system of justice says that everyone deserves a vigorous defense and that defense lawyers must act in the interest of their clients. Then it's up to the judges and juries to decide the guilt and innocence. All that makes a lot of sense in abstract. A recent case in Illinois was particularly challenging for non-lawyers to understand. Here's what happened. Two criminal defense lawyers went public to share information that their client had committed a murder for which another man was erroneously convicted. When the lawyers went public, the innocent man had already served 26 years in prison for a crime he did not commit. Most observers' immediate reaction was to say the lawyer should have spoken up right away, because it isn't fair for somebody to go to jail for a crime he didn't commit, and they should have stopped it. Because of attorney-client privilege is a central ethical principle in the legal profession, the lawyers were not allowed to share the private information. As lawyers, they understood that the larger system of justice depends on that principle, even if some individuals are harmed in the process of doing it. Interestingly, they also noted that if they had shared the information, it would not have been admissible in the court, and the court could not have helped the innocent man who was convicted. The lawyers were able finally to come forward only because years before they had convinced their client to sign an affidavit that they could share this information about his guilt after he died. It is important to do your own thinking because some professional communities provide limited guidance or none at all. For example, management is not a profession with explicit ethical standards and acknowledged professional responsibilities to society.